challenges. It's a really great kind of 360 overview, and we have a lot of material to cover today. So with that, I wanted to kind of introduce myself. I'm Jenna Ellis, and along with my colleague Dan Chichello, we will be your moderators today, and we'll be handling questions that you have, and we'll be saving those for the end. So you might hear Dan and I moderating, and so we wanted to say welcome and thanks for being here. And also, we wanted to welcome Harold Bishop and Melissa Skinner. They are our featured experts today. We're very lucky to have them. They are both writer-analysts in the Health Law Division of Wolters Kluwer Law and Business. So Harold, Melissa, welcome. Thank you so much for coming.
Thanks for having us.
Yeah, thank you.
All right. So I wanted to first start just with a general overview of some of the subjects we're going to cover. We're going to start, of course, with just a quick review of the decision. Then we'll move to some issues and cost premiums with the ACA, and then talk about some possible state reactions, and that's current state reactions, and then looking forward, as well as a look forward to the insurance market concerns, and also, especially because many of our attendees are representing employers or are employers, we'll talk about some employer implications after that. So with that, let's start briefly with the decision itself. So it was a 6-3 decision. It was written by Chief Justice Roberts. Melissa, can you tell us a little bit about this decision? And actually, when I was reading it, some of the words that stuck out to me were the use of ambiguity, and then also, of course, the death spirals. So can you give us a brief overview?
Right, of course. So basically, the decision upheld the IRS rule, which allowed individuals who are enrolled in the federal health insurance exchange to be eligible for subsidies. Written by Chief Justice Roberts, the decision was really resting on this 6 words that are in the Affordable Care Act, which are an exchange established by the state. Whether those words are ambiguous and whether they limit subsidies to just those individuals enrolled in state exchanges, or whether they can be applied to those enrolled in the federal exchange. One of the very interesting things about the decision was that the interplay with the Chevron Doctrine. So this is where the ambiguity issue comes into play. Chief Justice Roberts kind of surprisingly decided not to apply the Chevron Doctrine, which would allow courts to defer to the expertise of an agency when there is ambiguous language, so long as their interpretation of the law is not unreasonable. But he did not choose to go with the Chevron Doctrine analysis. Instead, he just took into account the entire context of the ACA and said that it would make little sense to deny tax credits to those enrolled on the federal exchanges. That's interesting to me because I think this puts the challengers of the law, in this case, in a worse position than they were prior to the case, because it forecloses the opportunity for another administration to come in, reinterpret the IRS law, and try to remove the availability of the subsidies from the federal exchange. So that's really the notable part of the decision that upholds this rule.
So what about the dissent then? I know, Harold, when you and I were talking, I was mentioning that it was one of Scalia's, usual kind of readable dissents. But what did he say? What was his view?
Well, it was a familiar Scalia theme. He argues that the plain meaning of the Affordable Care Act, which stated that the subsidies are available to enrollees in an exchange established by the state, should prevail, and the tax credits not apply to the federal exchange enrollees. He accused the majority of rewriting the statute to save the ACA. His concern is a judicial intervention of the court into the purview of Congress. This is a reoccurring theme with the conservative justices. He feels the lower courts are emboldened by this kind of decision to rewrite laws instead of interpreting them. And he thinks the plain meaning rule is important because it prevents judges from taking sides in legislative or political disputes. It's interesting to note, when mentioning Chevron, he makes no mention of it, so he must have agreed with Robert's interpretation regarding that.
Well, and I think that's interesting when we talk about the viability of the ACA, and really the ACA is here to stay, if you will. So we do have some remaining cases, but correct me if I'm wrong, but none of them are really a threat to the ACA's viability, right?
Well, it's interesting you mentioned the cases because the contraceptive challenges certainly are not a threat to the ACA's long-term viability. But yesterday the 10th Circuit ruled in Little Sisters of the Poor versus Burwell, and they ruled for the government, saying that the accommodation provided to the nuns was sufficient to prevent any substantial burden on their free exercise of religion. So I think now the 10th, the 3rd, the 5th, the 7th, and the D.C. circuits have ruled similarly in these contraceptive cases. But as you said, they're not a threat to the ACA's viability. There is one other case, the U.S. House of Reps versus Burwell. It's also known as Boehner versus Obama. In that suit, the House is contending that the administration is spending millions, or billions rather, on the ACA without congressional appropriation authority. And they also challenge certain executive orders that amend the ACA requirements regarding implementation of the employer mandate without congressional action. The issue in this case right now is standing, whether the House has standing to bring the suit. And it's before the U.S. District Court of the District of Columbia. And the general rule regarding standing is the House of Representatives must show that it has been personally harmed by the administration's actions, which have effectively nullified the votes of its members. I don't know if they can get over that hurdle, but we'll have to wait and see.
Okay. So when we shift then for a second to look at the decision and its effects, we have some, what I think most people would agree are clear winners, if you will, but also maybe some unexpected winners. So can we talk about those for a second?
Yeah, certainly President Obama, the Democratic Party, and the federal exchange enrollees that are going to get the tax credits that they were promised are the clear winners. There's also the health plans. This ruling ensures that their exchange enrollees will get subsidies. There's also been action among the health insurers with regards to mergers and acquisitions. In fact, within just a few days, Aetna and Humana announced their merger, which will be reviewed by the FTC or Justice, I'm not sure which, for possible anti-competitive concerns. And the reason I say I don't know which is the FTC usually reviews hospital and pharmaceutical mergers, and Justice usually does the healthcare insurance sector. So if that normal pattern stands, it'll be Justice. And it actually takes probably about a full year, and it's expected that Aetna will be asked to divest itself of certain Medicare Advantage plans that it has in the South and Southwest because they will overlap with Humana's Medicare Advantage plans in those areas. Cigna and Anthem are also reportedly in merger negotiations. So I think it's fair to say the ACA has been a merger catalyst in the health insurance area. The Aetna CEO said that it was an action-forcing event, and the Wall Street Journal says that the rush to merger reflects health insurance companies' desire to diversify to reduce costs amid the healthcare overhaul under the ACA. We're also seeing hospitals' stocks rising immediately after the decision. And we've seen doctor practice mergers recently, and we've seen doctor practices also joining local hospitals to reduce the cost of their electronic health record implementation and take advantage generally of hospital compliance expertise. One other thing interesting is Connecticut passed a bill on June 30th, which puts hurdles on health insurance and companies that try to acquire group medical practices in order to control cost. And the law will require that they file a certificate of need that has to be approved by Connecticut's Office of Healthcare Access. And if the certificate of need is approved, the Connecticut law would require the healthcare insurer to set up a website with billing and cost information for consumers. So we'll have to see if other states enact similar legislation. The big loser, I think, was the Libertarian group and the GOP. But maybe not in some ways, because I think it would have caused a lot of problems for them. If the ruling had gone the other way, I think the GOP governors and state legislatures would have been scrambling to decide whether they're going to establish state exchanges. And GOP legislators in Washington would have to consider passing legislation to extend the subsidies to the federal exchanges, which would have been vetoed by the president if they included anything in that legislation other than that. In other words, the draft legislation that we had seen would extend the subsidies, but they included a repeal of the individual or employer mandate, which would be a complete non-starter with the White House. So moving forward, I think the GOP might actually be in a better position. They can continue to criticize the ACA and offer alternatives. And if the ACA doesn't go well, the Democrats and candidates in 2016 will have to defend it.
Yeah, I think it'll especially be interesting as we go forward into the elections and to see what they do and what their stance is. So if we look forward, I guess, then to, price and money, and what are the effects of this decision on, on the sticker shock and rate hikes, et cetera? How is that playing out?
Well, no question. The biggest problem thus far and going forward has been cost. Medicaid expansion is going to obviously cost more, and we know now that of the 10.2 million exchange enrollees, 85% of them are getting subsidies. So the question is, as more people enroll in the exchanges, when they grow from 20 million to 30 million, will they need to be subsidized, and if so, how many? Will the number stay at 85%, or will it begin to drop down to 50% or some other number? With regard to just premium hikes generally, CNN Money reports that health plans are proposing large premium hikes. For instance, Blue Cross Blue Shield in Rhode Island is seeking an 18% increase. United Healthcare in Florida is also seeking an 18% increase in their exchange plans. Texas, Scott and White in Texas is seeking a 32% increase. Colorado plans range from a decrease of 5% to an increase of 34%. So Reuters reports that people are foregoing the ACA plans due to costs and applying for non-compliant policies despite the penalties they might have to pay. Kaiser Family Foundation reports in California that 44% of ACA enrollees find it hard to pay premiums compared to 25% that have their insurance through employers or other private insurance. So I think cost is a real key issue moving forward.
And what if we kind of group employers as well? The question that I have then is, if employers drop coverage because of costs or whatever and decide, look, I'm just going to pay the penalty, and then the employees look to the exchanges for coverage and get the sticker shock with the higher cost, is that a realistic possibility?
Yeah, well, there's a number of implications with regard to employers based on whether they're small, medium, and large. Is that what you want to discuss at this point?
Yeah, well, I was thinking employers, and I know we're going to cover employers in a little while, but I think it's just kind of an interesting note then to think about as we move forward. Who's going to pay for it and the continued price hikes and coverage. But I think it's also a good segue to possible state reactions and talking about, what happens then with these state exchanges. And maybe the states throw up their hands and say, let's just let the feds take over.
Well, that's an interesting question going forward after King v. Burwell, and I think that you can think about it in terms of where each kind of groups of states are now. There are certain states that have pretty much failed exchanges, and those are recently failed. A lot of them are recently failed exchanges, and a lot of these states are choosing to transition into some kind of state-federal hybrid, which is an interesting thought that we can come back to in a minute. But these states that have experienced recent failure with their exchanges can rest easy after King v. Burwell, knowing that their residents are still going to be eligible for the subsidies even if they have to sign up through a straight federal exchange or even a hybrid situation. And then, of course, there are states that have kind of successes, some of them surprising, maybe some of them not so much surprising. We would think they would continue on that course, but on the other hand, these exchanges cost money. They require a lot of time and a lot of strategy and planning. So you might also think that some of these states that are doing well might go in the direction of the federal exchange eventually anyway. And then the really interesting group is the middle group. So a lot of states we're seeing are experiencing small issues that might grow into larger issues. I call this these states are teetering on the edge of success and failure. And in light of King versus Burwell, you might think, why not just throw in the towel and go right to the federal exchange because it's already set up. And now with the decision, especially with Chief Justice Roberts' foreclosure of any future interpretations by the IRS by dodging the Chevron Doctrine, you can rest even easier knowing that if you do opt for the federal exchange, your residents will have their subsidies. So, and then maybe some hybrids can come out of this as well. I think a lot of those failed states are going towards that direction. And Section 1332 allows states to waive out of certain provisions of the Affordable Care Act as long as they can provide some kind of viable alternative. So it'll be interesting to see if any of the states dealing with these exchange issues take advantage of that waiver, because it gives a lot of leeway for innovation in those states. So it will not only be interesting to see if they take advantage, but it'll be interesting to see what they come up with, how to rethink an exchange or something else unique, something that works for the specific state, their specific needs and their problems that they had maybe been experiencing in the past, or maybe taking advantages of the successes that they had in the past with their exchange. But keeping in mind when we talk about these waivers, the waiver process is not always an easy road to go down. So it might prove to be even or just as difficult for states to invest their time and money in as maybe the establishment of an exchange was. So they'll have to weigh those options now that we're in a post-King v. Burwell world. And I think Harold has a little bit more to say on waivers at under Section 1115.
That's 1115 of the Social Security Act, and these waivers have been available for a while. They're Medicaid innovation waivers, and they give the Department of Health and Human Services the authority to approve experimental, pilot, or demonstration projects that promote the objectives of the Medicaid and CHIP programs. And recently, conservative Republican Governor Mike Pence of Indiana and the legislature there began pioneering an experiment that requires low-income patients to contribute monthly to a special health account, very low amounts, between $1 and $27 a month. It's interesting that Arkansas and Iowa have also implemented cost-sharing requirements in their Medicaid expansions, and other officials in Utah, Arizona, and Ohio are also reportedly thinking about the idea. Secretary Burwell, who would have to sign off on Section 1115 waivers, says she welcomes the conversation. Not sure if that's a ringing endorsement, but we'll have to wait and see what happens there too.
So let's move then to what we're looking for, what we're watching with insurance market concerns. I know, Harold, you classify some of what we're watching as the 3 R's. Yeah,
there's 3 federal backstops, 2 of which end in 2016, at the end of 2016. They're risk corridors, risk adjustments, and the transitional reinsurance program. And they're designed to help reduce insurer losses until the individual insurance markets stabilize. Risk corridors compensate insurance companies that end up with higher costs than they expected. For example, if an insurer's actual claims in 2014 were at least 3% greater than the claims they projected when they set their 2014 rates, the government has to step in and reimburse the insurer for 50% of the excess. If the actual claims jumped 8% beyond projected claims, the government covers 80% of the excess. This has been going on since 2014. It'll go through the end of 2016 when it'll end. The second one is risk adjustments. Now, this is a permanent program, and this requires insurers with a higher percentage of low-cost enrollees to contribute to a fund that makes the payments to insurers with a larger percentage of high-cost enrollees. The third one is the transitional reinsurance program, and this is kind of a supplement to the risk adjustment program, and it compensates plans when they have enrollees with especially high claims. For instance, plans are reimbursed 80% of an individual's health claims between $60,000 and $250,000. Again, this one expires after 2016, and the upshot of this is the CBO, the Congressional Budget Office, predicts that the removal of the risk corridor and the transitional reinsurance programs at the end of 2016 will result in at least a 1 year larger than normal increase in premiums. There's also another thing that begins in 2019. That's a cap on subsidies. So starting in 2019, if the combined premium and cost-sharing subsidies exceed 0.504% of the gross domestic product, the subsidies available to the exchange enrollees will begin to be reduced, and which will require enrollees to shoulder a larger share of their planned premiums.
So those are the 3 R's, and then if we, I guess if we circle back from what we touched on earlier, and we look from the perspective of an employer, or maybe someone advising an employer, there's several requirements, happening, I guess, now through 2018, I believe.
Yeah, there's, well, we can talk about small, medium, and large employers. I think it helps to look at it that way. Naturally, small employers, they're not subject to the employer mandate. But now that King versus Burwell has stabilized the federal exchange subsidies, it's more likely that those small employers that are providing insurance to their employees will let their employees enter the exchanges instead, and maybe give them some kind of financial assistance in doing that. Medium-sized employers, those with between 50 to 99 full-time employees, they were supposed to be subject to the mandate in 2015, but that was delayed a year by executive order. So now in 2016, they're going to have to comply. Large employers, those with over 100 employees, began complying in 2015. By executive order, the large employers were required only to have 70% of their employees covered with ACA-compliant plans in 2015. The statute said 95%, but it was reduced to 70%. But going forward in 2016, it'll be the actual 95%. One other thing with regard to small employers, there was just on July 7th of this year, the House and Senate both introduced bipartisan bills. One is H.R. 2911, the other is Senate 1697. They're known as the Small Business Healthcare Relief Act, and their purpose is to roll back existing Treasury guidance, which was issued under the authority of the ACA and which prohibited the use of things called health reimbursement arrangements, HRAs. The Treasury guidance disallowed employers from using standalone HRAs to reimburse employees for their health care expenses because the arrangements did not satisfy the ACA's minimum benefit and annual dollar cap requirements for health insurance plans offered by employers. As a result, employers that continue to offer HRAs would have been subject to a $100 per day per employee penalty. When Treasury heard about the House and Senate concerns, they delayed enforcement until July 1st of this year, and now this legislation would ensure that small businesses and local municipalities with fewer than 50 employees are allowed to continue using these HRA funds, and it'll protect the employers from being penalized financially.
What about things like the Cadillac Tax?
Yeah, the Cadillac Tax is the high-end plans that have low deductibles and low cost sharing, which according to the government encourage heavy use and therefore increase healthcare costs. And starting in 2018, the Cadillac Tax will be a 40% excise tax on the aggregate cost of these group health plan coverage that exceeds specified thresholds. However, there's bipartisan support for repeal of this tax, so it could very well disappear. Ann Hewitt research also shows us that 2/3 of companies are considering altering their age 65 retiree health strategies. This is people that retire before their Medicare age, with 35% favoring sourcing their health coverage through the public exchanges and 28% considering eliminating the pre-65 retiree coverage and subsidies altogether. The A.N. Hewitt actuary and leader, John Grosso, has said, quote, "Now with the case decided," referring to King versus Burwell, "it's likely we could see aggressive movement from companies in the 2016 to 2018 time frame, which enables them to avoid the excise tax risk on this high-cost retiree population."
I think that's a great example, and I think even though maybe the ACA is here to stay, the ACA is here to stay, but I think it's really safe to say that all of these implications, dates, concerns are really going to keep us watching all of these effects and then keep the ACA in the news. I know we do have some questions, and before I get to that, I just want to remind everyone again, we always get questions about the handouts, and if you go down to the handouts portion of your toolbar, there are the slides available for download, as well as the white paper that was written about the decision. So those are available for you to download right away. And Dan, before I get to questions that you have, if you have any, I have one. It says, what is going on? Are there any new developments in the hospital sector? I don't know which one of you wants to field that.
Well, this is Harold. Because of Medicaid expansion, and the new insured enrollees, people who haven't had insurance before, there'll probably be initially a drop-off in emergency room use as these people discover that they can go to primary care and then get referred to specialty care if necessary. So this should result in a shift of assets, away from the emergency room into primary and specialty care. I think overall for Medicare, the ACA shifts hospital payments from traditional fee-for-service to alternative payment models going forward. And these alternative payment models stress quality of care. And I know the CMS has a goal in 2016, which I believe is 30% of these Medicare payments being tied to these alternative payment models. And I think it increases to 50% for 2018. There's also something that's already in effect. I think it's been in effect since 2012. The ACA required charitable tax-exempt hospitals, some new rules, and those are hospitals that fall under IRS code 501c3. And the Affordable Care Act created a new section 501R, which imposes new requirements, and generally there's 4 of them. They have to establish a written financial assistance and emergency medical care policy, and they have to limit the amounts charged to individuals that are eligible for assistance under these policies. And before engaging in extraordinary collection actions, they have to make reasonable efforts to determine whether an individual is eligible for assistance under these policies. But most importantly, they have to conduct a community health risk assessment, known as a CHNA, and adopt an implementation strategy at least once every 3 years. And if they fail to do so, the ACA also imposes an excise tax of $50,000 for failure to meet these community health needs assessment requirements. So that's just some of the concerns for hospitals.
Okay, great. And Dan, do we have any other questions?
No, I don't have any others through the chat.
Okay. Mary, are you still on with us?
No, I am indeed.
Okay,
I am.
There was one question about downloading the handouts. They're in the handout section. Are there links to that?
There are, I think this is the only person having an issue. So, Lynn, if you're out there, I'm going to go ahead and email those directly to you. You should have them in your mailbox in a moment.
Perfect. I wanted to thank our experts, Harold and Melissa. Thank you so much for your time and your expertise. We really enjoyed working with you and presenting this.
Likewise.
And I wanted to, thanks. I wanted to also thank all the attendees. Thanks, Melissa. I wanted to thank all the attendees. We really appreciate your being on with us. We will also, my information is up here if you have any questions or any follow-ups that you'd like. My email address is up on your screen. And additionally, we will also just be sending you a really, really short survey. If you could take 2 minutes to fill it out, it helps us know what topics you're interested in and what topics maybe our experts could do a Waits webinar about. So we'd really appreciate your feedback for that. But with that, I wanted to say thanks, everyone, and thanks for attending the King v. Burwell Waits webinar. Have a good day.